All right, so let's pick it back up here. These are the current 9 members of the North Carolina Real Estate Commission. You've got to learn their names and birthdays, like I said, so you can send them a card every now. I'm just kidding. So we want to talk about the makeup of the Real Estate Commission versus the Real Estate Commission staff. That is 2 different things. When we talk about the commission with a capital C, we are talking about these 9 people right here. These people are political appointees. They are appointed. When we say they're political appointees, I don't mean that they're political people. I just mean that they are appointed by the politicians of the state. All right? So, when you are the governor, you have the right to appoint members to the North Carolina Real Estate Commission. In fact, 7 of the 9 are appointed by the governor. Now, not all at one time. They rotate on and off. They serve 3-year terms. Okay? So, yes, they can be reappointed. That generally happens when their term comes up and the same person who appointed them is still governor. What do you think happens when people's term comes up currently, considering we have a new governor, and particularly another governor from a different party? Are those people likely to be reappointed, or are they likely to be switched out for new political appointees? Okay, so there you go. That's how that works. So the governor gets to appoint 7 of these people, and then 1 each from the North Carolina House of Representatives and from the North Carolina Senate. So the General Assembly gets to appoint 2 of them, and the governor gets to appoint 7 of them. The rules for them, there at least 3 of them must have a real estate license at any given time. So at least 3 of the 9 must have a real estate license. And then at least 2 cannot have a real estate license. So 2 of them have to be completely uninvolved from the real estate industry. What do you think the purpose is of that? We don't want all brokers there because they're making the rules that govern who? Brokers. We need the input of the public, somebody who doesn't have a vested interest in these rules. There's a fear that if you have only brokers there, that they might not make rules that are strict enough on themselves. Does that make sense? So there have to be at least 2 of them who don't have a broker's license who are on the commission at any one given time of the 9. Everybody with me on that? So the function of these people: make the rules. That's their job. They vote on what the rules will be that we have to follow. They also vote on who gets a real estate license. Now, part of getting a real estate license for you guys is going to be going through a character check, a background check. You will have to submit a background check with your application. If there's absolutely nothing on your background check, then these 9 people will never see your application. If there's nothing on your background check, you pass the test, guess what's going to happen? License is going to be issued. If there's something on your background check, you're going to be expected to explain it. That's when these 9 people will see your application. Because if there's something on the background check and you have to explain it, they have to decide whether or not to issue you a license. Does that make sense for everybody? It's called the character review process. So one of their functions is to every month look at the license applications for people who have character issues on their background check and decide, do we just want to issue the license? Are we satisfied with their explanation? Do we want to bring them in to talk to us? Do we want to deny their license? That's how the character review process works. Now notice, they don't even look at your character until you've already passed the license exam. So when people say, well, are they going to give me a license? The first thing you have to do is what? Pass the test. There's no way to answer the question of whether they're going to give you a license until you pass the test, because they don't even look at the application until you've already passed the test. Does that make sense for everybody? Okay. You have to submit the criminal background check before you apply, but they're not even going to look at it until after you've already passed the test. That's the way their process works. All right? Now, these people do not work at the Real Estate Commission. These are not employees. They're not paid. in any way, shape, or form. They come from all over the state. They come once a month for a meeting. It's a 2-day meeting once a month. They take care of disciplinary actions. So, if there's a disciplinary action in front of them, what that means is that somebody who works for the Real Estate Commission has investigated a complaint and has created a case against a licensee, and it becomes like a trial. And guess who the judges are? These 9 people. So these people are the ones making the decisions. There's a whole staff full of employees who are enforcing the rules. Their job is to enforce the rules that these 9 people make. Does that make sense for everybody? Okay? So that is the makeup of the North Carolina Real Estate Commission. And those meetings are open to the public if you ever want to attend one. If you specifically want to go, let me know. I'll go with you. So you won't be scared. Alright? Okay? Their disciplinary authority, what can they do? Reprimand licensees. So what's a reprimand? What kind of punishment specifically?
Like a warning, maybe?
Warning. Don't do it again. Let me show you what a reprimand looks like. No, I did not get reprimanded. Thank you very much.
I'm sorry.
But I'm going to show you what one of theirs looks like.
You just said, let me show you. Show you what it looks like.
I said, let me show you what one looks like, not one I got.
I didn't think it was open to
I have never been reprimanded. Yes, and that's why it's a punishment. Because it's a publicly available document. So every quarter, the Real Estate Commission publishes something called the Real Estate Bulletin. Actually, let's pull up.
They put it in the real estate bulletin.
Right.
That's embarrassing, yo. Wait, so remember that ad you showed us in the newspaper back in the day with the girl in the car she was on?
I wonder why I pulled that one up. Oh, look who's in there. See, I have been in the bulletin, but not to be reprimanded.
Very
So,
handsome.
well, thank you very much. So, by the way, if you ever want to visit that trophy, it's in the lawn. Alright? But if you are reprimanded or disciplined in any way by the commission, they put it in the bulletin. So, let's see. So let's see what Mr.
Cooper.
Randall Casper Craven did. Following a hearing, the commission permanently revoked the broker license of Mr. Casper effective January 30th, 2017. The commission found on September 8, 2016, Mr. Casper pleaded guilty to 1 count of felony larceny after breaking and entering, 1 count in each of 4 cases of felony obtaining property by false pretenses, 1 count of felony identity theft in each of 6 cases, and 1 count of felony larceny. That Mr. Casper was sentenced to a maximum of 25 months of incarceration, given credit for 62 days of conviction. They get detailed, don't they? Prior to his plea, in order to spend an additional 45 days in jail, after which the remainder of his sentence was suspended. He was placed on supervised probation for 60 months. That Mr. Casper was ordered to pay restitution and court costs totaling $34,560. That is a condition of his supervised probation. Respondent was prohibited from engaging in real estate brokerage in the state of North Carolina. And that he failed to respond to 2 letters sent by commission staff because he was in jail. That's why he didn't respond.
So is this something he did with real estate?
No, it sounds like this was completely unrelated to real estate, but they revoked his license because of the convictions.
Wow.
So there's another permanent revocation with Mr. Cooper. So revocation are obviously something they can do. Here's a reprimand. Chesley G. Bowens Jr. The commission reprimanded Mr. Bowens effective January 1 of 2017. They found that Mr. Bowens entered into an exclusive buyer agency agreement with 3 buyer clients in which they agreed to compensate Mr. Bowens $1,000 for his services. That the exclusive buyer agency agreement was not for a definite period. They have to be for a definite period, right? That the buyers were Spanish speakers and Mr. Bowens did not speak Spanish. That's kind of a problem. That on December 29, 2015, buyers submitted an offer to purchase property with a due diligence period ending January 8, 2016. That the buyers were unable to obtain financing and the sellers terminated the contract. That Mr. Bowens requested that his buyer clients pay an additional commission based on his fulfillment of his duties. But he was not entitled to additional compensation under the terms of the exclusive buyer agency agreement. That the buyers did not pay the commission demanded. Well, good for them. I'm glad they didn't. That was a reprimand. That was a reprimand. So that is what a reprimand from the real estate commission looks like. And here's the real punishment of that. It's not just that brokers see it, because brokers do see it. What do you think is going to come up when somebody Googles that guy's name? This. Because this was placed out there by a regulatory body, right? It's going to be highly indexed on all those Google searches. So that's the real punishment, is getting yourself at what you find.
Andrew
Middle ditch.
DUI manslaughter.
When you drive over
found
90
that
miles,
Mr. Middleditch entered into a plea to 1 count of felony DUI manslaughter and 1 count of misdemeanor DUI second offense within 5 years.
So he was in Virginia.
He timely reported these criminal convictions to the Commission and to the Virginia Department of Professional and Occupational Regulation, and he's in compliance with all court-imposed requirements.
Up here, if you do more than 90, they call it
He
manslaughter.
was reprimanded, but that's because it didn't relate to real estate. You know, so they're taking a disciplinary action for something completely unrelated to real estate, and it says that he timely reported the conviction. My guess is if he had not timely reported the conviction, they probably would have suspended or revoked his license. You know, so they're basically saying, you did everything correctly and you're still going to get reprimanded because this is clearly bad stuff. So we want the public to be aware that you have these convictions out there, you know, and you still got a license.
But he's still an agent.
He is still an
So with
agent.
a DUI, more than likely, he's going to drive with his license.
Well,
They want to get in the car.
He had just 1 glass of wine.
well, and keep in mind the court-imposed requirements may be that he doesn't have a driver's license. It doesn't say that, right? It says he's in compliance with all court-imposed regulations, so it may be that he doesn't have a driver's license. That may be part of the reason. Yeah, right. Maybe somebody's driving him around. All right. So their disciplinary authority is to reprimand, to suspend, and to what? Revoke. All right.
And so what time shift?
They can find timeshare developers. That's the only person that can be fined by the Real Estate Commission is a timeshare developer. All right. But they can never fine what? Licensees. Real estate licensees can never be fined by the Real Estate Commission. Period. All right? So, what things do we not do as brokers? What things can the Commission discipline us for? Well, obviously violating any of their rules. That would be number 1 on the list. Don't do that. Number 2, practicing law. You're going to see that as a test question. So give me some examples of practicing law. So writing contract language, any kind of drafting contract language. What are we allowed to do when it comes to contracts? Fill in the blanks, that's it. If we're writing in any kind of phrase, that's called practicing law. What else would get us in trouble as far as practicing law?
Giving legal advice.
Giving legal advice. So what would be an example of something that somebody could ask me in a real estate transaction that would probably be legal advice? Think about like contracts. If I terminate this contract, what's going to happen to my earnest money? Now, can I say, this is what the contract says?
Yes.
Yes, because then I'm just giving them the language that's in the contract. But if they say, well, what does that mean? Can I answer that question? No, because what does that mean means if they can't understand the language, then I can't interpret it for them. Does that make sense for you guys? If they look at covenants, and the covenants say you can't put in a swimming pool, and they say, well, can I do a swimming pool? And I said, well, if the covenants say no swimming pools, well, what does that mean? Can I have a swimming pool? Go talk to an attorney. Does that make sense for you guys? The way I always think of it is you can usually answer the first question but not the follow-up one. You know? Because the first question you can usually just say, this is what the thing says. Giving advice on how to take title. Can you explain to them the difference between joint tenancy and tenancy in common? You can explain the difference, right?
But you can't.
Can you answer the question, which one should I do?
No.
No, that's giving legal advice. You see the differentiation there? Everybody good with that? So that's the big one for the commission. Don't practice law. Don't self-deal. Self-deal means you're doing something that puts yourself ahead of your client. I'll give you an example. I go into a listing presentation, and I realize about 10 minutes into talking to these sellers, man, I like this house. I'd like to buy this house myself. What should I do at that point in time? What should I do? It's a listing presentation. What am I there to do? Solicit their business to do what?
Sell the house.
Sell their house. If I have interest in their house, what should I do at that point in time? Tell them, stop the listing presentation because I can't possibly represent them as a seller if I'm interested in being the what? The buyer. Does that make sense for you guys? That's what we mean by don't self-deal. When you have an interest in something, you stop the transaction, you let everybody know, you warn them, you say, hey listen, I would like to participate in this transaction. And they need to make their decision at that point in time. Okay? And obviously no misrepresentation or omission. Remember, you're going to see those questions on the... How'd y'all do on the midterm with the misrepresentation questions? You do okay with those?
Well.
Good. 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 Now, what will the commission not get involved in? This is definitely going to be on the test. The easiest way to describe this is anything relating to money. The commission is not going to regulate how much you charge in commissions. The real estate commission is not going to tell you how much you should charge, how much is too much, how much is not enough. They're not going to tell you you should split this commission with that firm, or you didn't split this commission appropriately with this firm, or you owe these people their money back, or you've got to refund this money to this client. Simply put, they're not going to do anything relating to what? Money, commissions, refunds. They can't even force... Suppose you steal $50,000 from your trust account. Can the commission force you to pay it back? They don't have that authority, folks. Who could force you to pay it back? A court of law. So when we say what could happen if you violate license law, well, that's not just what the real estate commission can do. What can the real estate commission do if you violate license law?
You can revoke your license.
Revoke, suspend, or reprimand, right? What else could happen to you as a result of violating license law?
You can end up in court.
You can end up in court getting sued, so they call that civil penalty, right? A civil penalty is being sued. How about a criminal penalty? Could you end up in jail?
Yes.
Sure. Not the real estate commission can't do that, but a district attorney certainly could, right? And so sometimes when the real estate commission disciplines people, if somebody files a complaint to the real estate commission for they stole this money out of the trust account, and the real estate commission investigates, and they find that that broker did indeed steal money from, the real estate commission is probably going to revoke the license. They can't do anything else, but could they pick up the phone and call the district attorney in that county and say, by the way, we just revoked somebody's license for stealing $50,000 from a trust account. You might want to take a look at this. Could they do that?
Yeah.
That's called a referral. It's called a criminal referral. They can do referrals too. Whole different referral than we're used to, though. All right? And could they look at the person who filed the complaint and say, now we can't get you your money back, but you could certainly sue them to get your money back? And they probably would say that to somebody in that case. Does that make sense for you guys? They don't have the authority, but that doesn't mean it can't happen. But make sure you don't answer on the test anything that relates to the real estate commission getting involved with money, because they're not going to do that. All right? Reporting stuff to the commission. We have 10 days to report a change of address. 10 days. 10 days to report a change of address. 60 days to report a criminal conviction. Not a charge, but a what?
Conviction.
A conviction. So if you have a license and you're convicted of a crime, you have 60 days to report that to the real estate commission. You only have 10 days to tell them if you move. I don't know why moving is worse than killing somebody, but apparently, I'm just kidding, it's not, no, you know. But just two different rules, 10 days if you move and 60 if you're convicted.
Well, what if you,
What if you move while you kill somebody? I don't know.
what if you're found not guilty and they expunge the record with it?
That's not a conviction.
So,
You do not have to report it.
okay.
You do not
Convicted.
have to report it. Are you asking for a friend or what? Now, I will say this.
If anything, I'll kill Jack.
I will say this. If you have a charge, even if you were found not guilty, that will show up on your criminal background check as a part of the application process, and you will have to explain even things you were found not guilty for. Obviously, that's a quick explanation. I was found not guilty, you know, but it will come up, and you will have to explain it. I'm giving you fair warning in advance. When I applied a lot of years ago, I had failure to return rental property on my criminal background check. Yeah, I was like, what? I was like, what the heck? I don't remember renting anything. A VHS videotape from Bizart Video in Chapel Hill.
Oh my
Of Mission Impossible.
Stop.
And apparently I had rented a movie and never taken it back, and they had filed failure to return rental property in Orange County Court against me, and I had no idea. I had no idea. Yeah, and
What's this store called?
I had to go to the county courthouse
Oh my God.
and pay the fine and deal with the thing. I had to go in front of a judge, and the judge said, "You're here for what?" And I looked behind and I said, "Sir," he said, "This is the most ridiculous thing I've ever seen in my life." And he dismissed it instantly, you know. But then I had to explain that on my application to the real estate commission. But I had no idea until I did the criminal background checks. I'm just warning you, you may find things, you
Wait,
know,
the first Mission
when you
Impossible?
do that background
So you
check.
have to do it yourself?
They have a
First
company
Mission
you have to
Impossible,
use.
bro.
Okay.
Yeah, it's the web address is
98.
ncreccheck.com.
Wow.
They have a company that they've contracted with that you have to do it through. All right? And it has to be done through that company. You can't substitute a different
I'm
one.
pretty good at it.
And they report it. You don't have to do anything other than pay for the background check. They send it directly to the real estate commission. They send you a copy, but by the time you get the copy, the commission's already got it.
Traffic violations should show.
They do show up.
Oh, well, dang.
Anything above a normal speeding ticket. So,
Are you serious?
yeah,
What's a normal
careless and
speeding
reckless, all of that.
Except for
Huh?
So all you have is speeding tickets.
More than
Oh, what
15.
is-
I'm
You don't
sorry.
have to explain speeding tickets.
If it's
Generally
normal.
speaking, you do not have to explain
How
speeding
fast
tickets.
you're doing,
Right.
100
But it depends on the amount of speed involved, because sometimes, you know, like a speeding conviction more than 10 over is careless and reckless, and you would have to explain that.
You have like a
I might have one to
PJC.
explain that.
Okay.
We have PJC.
So just prepare, you know, whatever little gremlins are hanging out there, you'll have to explain them. They are very lenient if you take ownership. What they don't want to hear is, "I was young and stupid." They get that. What they want to know, are you still stupid now that you're old? They want to know, have you changed? You know, what adjustments have you made that are going to prevent this from happening again? You know, they want you to take ownership of it. That's what I've noticed is the biggest trend. The people that have the, you know, least problem with it are the ones that just say, "Listen, I was 19, I got arrested because we were smoking pot in the bathroom in my dorm, and I obviously realized that was a really dumb thing to do, and I would never do that again at this point in my life, and that's the only charge I've ever had." You know, it happened 30 years ago. They don't care, you know what I'm saying? But if you just put on there, "I was young and stupid," they're going to come back, "Well, how stupid are you still?" You know, like, and you're going to delay your licensure, and you may have to go talk to those 9 people, and you don't want to do that. So if you have something on there, just take ownership, give them as detailed of an explanation with, you know, what actually happened. You know, I had a young lady who just finished the class, and she got a DUI last year in New York State. Well, and the deal was, one of her best friends was killed in a car accident. She got a phone call when she was driving home from work that it had happened, and she pulled over to a restaurant, and she had 2 glasses of wine while she was sitting at the bar trying to collect herself, and she got pulled over pulling out of the parking lot. And she was terrified because she had just had a DUI last year that they weren't going to give her her license. I said, give them the details of what happened. Tell them the whole story. She never even got the call for having to have a character conference. It her license was issued instantly. So if you are detailed and it's a reasonable explanation, you're not gonna have a problem, okay? We have given people licenses with much worse than what you have, I promise. Whatever it might be, people have done worse. I mean, they're not out to keep people from getting a license. They want to make sure that people have an adequate chance. All right? We talked about advertising. Who did we say was always responsible for the advertising? The bid. So you need to know what is required in an advertisement, because they're going to give you sample advertisements on the test, and you'll have to identify which one is legal and which one is not legal, okay? This is called looking for a blind ad. A blind ad is one where a consumer, a member of the public, looks at the ad and they have no idea who placed the ad. When a consumer looks at an ad placed by a real estate broker, they should know it was placed by who? A real estate broker. So that means the ad has to identify one of two things. Either the broker, and broker is not a provisional, so either the full non-provisional broker who placed the ad, or the firm who placed the ad. Does that make sense? So, could a provisional broker's name be on an advertisement?
No.
It could,
Okay.
but it's not enough. What would have to also be there if it was a
Firm.
provisional broker's
Right.
name
Okay.
is the firm. Whereas with a non-provisional broker, is their name enough?
Yeah.
Yes, because the rule says that it must identify either the broker or the firm, one or the other. So I've given you 3 examples here. The first 2 are okay. 148 Main Street, 3-bed, 3-bath, 1,850 square feet, $178,000. Call Bob Kastner, comma, broker at blah, 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 blah. That's an allowable ad because it identifies what? The broker who's placed it. It's clear that you're calling a broker. The second one's okay. Same property. Call Bob at United Real Estate Raleigh. Well, it didn't identify the broker because Bob is not, we don't know that Bob's a broker, right?
Right.
But it identified what? The firm. That's okay. The last one's not okay. Call Bob at 919-555-1212. What's wrong with it?
We don't know no information.
It doesn't say broker or firm, but more importantly, who the hell is Bob? If you're looking at that ad, Bob could be who?
Your next door neighbor.
He could be the seller,
Right.
right? You have no idea that you're calling a real estate broker when you call that number. Does that make sense? And that's what makes it a blind ad, and that's not allowed. Is everybody okay with this? So on a test, you need to be able to identify what a blind ad is. How long do we have to keep records?
3 years.
3 years after we stop working for this person. So 3 years after we last provide service to that person. Our clock starts ticking when we stop working for the person. So it's not that we have to keep records 3 years, it's we have to keep them 3 years after we finish doing the work. So let me give you an example of what I mean there. Sales transaction is pretty easy. It's 3 years from what? From closing, right? So I have all my records for the transaction, and I have to keep them 3 years after we close on that transaction. Does that make sense for everybody? What about property management? What if I've been managing this apartment complex for the last 15 years? How many years of records do I have to have? Have I stopped working for them yet?
No.
So how many years of records do I have to have? All 15. And how long do I have to keep all 15 years worth of records? 3 years after I what?
Stop working.
After I stop working for them. So I have to keep all records pertaining to that transaction, and that transaction took 15 years because I managed that property for that long. And I have to keep the records for 3 years after I'm done with the transaction. Does that make sense? That's different than saying I got to keep 3 years worth of records, right?
Right.
Is everybody okay with me on that? So think of your record keeping as this. Any client I'm currently working with, I got to have all the records. No matter how many years back that relationship goes, if I'm currently working with this client, this transaction, I got to have every single record for that client, right? Does that make sense?
Yes.
And from the day I stop working with that client, I got to keep them for an additional 3 years. That's the way the 3-year rule works. So when you close the file on that client, put it on the shelf and keep it for 3 years. Okay? We talked a lot about dual agency. These are just some of the reminders of the rules of dual agency. Dual agency is defined as a firm representing both the buyer and the seller, not individual brokers, right? The firm is representing the buyer and the seller at the same time in the same transaction. Always remember with dual agency, if the firm's a dual agent, then every broker in the firm is a dual agent. So let me ask you a question. Zach takes a listing. Let's say we all work for the same firm, okay? This is a sales meeting. Zach takes a listing, and Sharon is working with a buyer client who wants to make an offer on Zach's listing. How many of us are dual agents? All of us. So Sharon is representing Zach's seller just as much as she is her buyer, correct? And Zach is representing Sharon's buyer just as much as he is her seller. Tell me something. Who is entitled to see the personal and confidential information of that seller? Everybody. Not just both of those two, right? Everybody, because we all represent that seller. Who's entitled to see that personal confidential information of that buyer? Everybody, because we all represent that buyer. Now, entitled to doesn't mean it's a good idea. Because if we all saw the personal confidential information of the seller, what kind of agency would we be preventing that our firm might want to practice? Designated dual agency. So just because we're entitled to it doesn't mean it's necessarily a good idea to access it, right? Because if Sharon's seen the seller's confidential information, we couldn't do what with her? We couldn't designate her. And if Zach has seen the personal confidential information of the buyer, then we couldn't designate him to represent the seller. Could I, assuming nobody's seen personal confidential information, could I designate everybody on this side of the room to represent the seller and everybody on this side of the room to represent the buyer? Yes, we can have multiple brokers. So don't make assumptions on these agency questions. Here's the thing. Here's what they're going to prey on. They're going to prey on the fact that as soon as I say, Sharon is working with a buyer client, and Zach is a broker affiliate of the same firm who has a listing. Sharon's buyer is interested in making an offer on Zach's listing. They're going to prey on the fact that you're going to assume that's designated dual agency because I said it was two separate brokers, right? Have I said anything so far that would make it designated though? All it is what? It's dual agency. It's not designated until I make it clear that it's designated agency. I would have to say something about like, Sharon is advising her buyer client on the price they should offer. Well, as soon as I use the word advice, we're in designated, because the only type of dual agency where anybody can give advice is designated. Does that make sense? Don't make the assumption that just because it's two separate brokers that it's designated. And don't assume that if it's designated, that means we can only designate Zach and Sharon. We can designate 4 for the seller and 2 for the buyer, or vice versa. Anybody I want to designate as the BIC is fine.
See, I wasn't thinking that way. I was thinking designated was 2 people.
1 and 1. It doesn't have to be that way.
Yeah.
So I'll give you an example. Say they're both provisional. I can designate 2 provisional brokers against each other, right?
Yes.
But as the BIC, does that put me in a rough position? Because I'm supposed to do what with provisional brokers? Advise them. I can't give advice to both of these people who are working against each other, right? So if I had 2 provisional brokers in that situation in my firm, what I might say is, Zach, you work with Leslie. She's going to help you on the transaction because I trust her that she can give advice just as good as me. And Sharon, you work with Carlos because he can help you. So I'm going to designate 2 people to the seller and 2 people to the buyer, so that way I can kind of step away and not have to be in that conflict of interest. But I can do that as the BIC. Does that make sense for everybody? Okay, good, good. Dual agency always requires the written permission of both parties before an offer can be presented. Remember, you can get oral permission from a buyer up to the time of offer if they have an oral buyer agency agreement. Once they put it in writing, the permission's got to be in writing. Does that make sense for everybody? Okay? The parole evidence rule, once you put something in writing, you can only change it with more writing. More writing. That's what the parole evidence rule is.
Yeah.
When you put something into writing, you can't change it orally. You can only change it with more writing. In other words, if we ended up in court with that document, what is the judge going to look at? What's in writing or what you're telling them?
What's in writing?
They're going to look at what's in writing. That's what the parole evidence rule is. Okay? Designated, remember, it's still dual agency. First and foremost, you have to get permission for dual agency because designated is a form of dual because the firm is still representing both the buyer and the seller. Remember, any combination of brokers is okay in designated except one. What's the one exception that's not allowed in designated dual agency? There's only one situation.
A bid can't be against,
A provisional. A bid can't be against a provisional broker in their supervision. Okay? So, go back to our situation. Let's say Sharon does have that buyer client, and she's a provisional broker. And I, the BIC, have the listing. Now, I can designate myself to represent the seller as the BIC. There's no rule against that. Okay? If any other broker in the firm were designated with the seller, I could designate Sharon to represent the buyer because there's no rule against Sharon as a provisional being a designated broker. But there's a problem when I'm designating a provisional broker in my firm against me as the broker in charge. Because she's supposed to come where for advice? Me. How in the hell is she going to do that if I'm against her? Does that make sense? So can I have two provisionals against each other?
Yes.
Yes. Can I have a provisional against a non-provisional?
Yes.
Yes. Can I have BIC against a non-provisional?
Yes.
Yes. Can I have BIC against provisional in their own firm?
No.
No. No. Okay? Good. Good. Remember, don't let them trip you on the easiest things on the test. Like, if they're talking about the form of dual agency, don't the agents have to work for the same firm?
Yes.
And I've seen test questions where they say, which of the following cannot be designated dual agents? And the answer was two agents in separate firms, and people still miss it. Like, well, of course they can't be designated dual agents because they're not. It's not even dual agency.
Right.
They're in two separate firms. Does that make sense? So be very careful of that kind of little tricky stuff.
Probably the pressure.
It is the pressure, for sure. Okay?
Well, those I can appreciate. It's the ones where it's like Julie works for,
Right.
and
All the names.
all these 10 people work
Yeah.
here.
Yeah, exactly.
100% of this doesn't have
Larry,
anything
Moe,
to do
and
with
Curly
it.
work for Three Stooges Real Estate. Okay?
He said.
Disclosing compensation. What compensation do we have to disclose?
What we charge?
What do we have to disclose as far as our compensation goes?
All of it.
All of it. Every cent, every dollar from every source, whether we're being paid by our client, the other person in the transaction, another brokerage firm, a third party, like a lender giving us a kickback because we sent them business, or a home inspector giving me a gift card at the Angus Barn because I had them use him for a home inspection. My client's got to know about every dollar of it. Always. We always disclose. Do we disclose bonuses to our client?
Yes.
Gas card?
Yes.
Commission?
Yes.
Kickback? Referral fee? Anything. We disclose every dollar that we're being paid to our client because they always have the right to say no. They always have the right to say no. Be careful though. Yes, we disclose it. Where do we not put it? On the sales contract. It's a good thing to disclose your commission. It's not a good thing to disclose it on the sales contract because there's a rule that says it can't be mentioned on the sales contract. What are the two things that can't be mentioned on the sales contract? Commissions and what? Not a non-disclosure statement. That must be there. A non-discrimination statement must be there. There's one other thing that can't be there. Travis will not be held responsible for any problems that come out of this transaction. It's called a liability waiver. You can't put any statement that the brokers are not at fault. It's called a liability waiver. You can't write into the contract that the brokers aren't responsible because guess what? They are responsible. They are responsible. Alright? Talk about trust accounts. A trust account or escrow account, they mean the same thing. Trust or escrow means the same thing. E-S-C-R-O-W. Trust or escrow. A trust or escrow account is an account that is separate from your money, designed to hold other people's money. That's why it's called a trust account. Does that make sense for everybody? So here's what you need to understand about a trust or escrow account. Generally speaking, when money goes in there, it belongs to more than one client. That's mostly the case. That's the whole point of it being a trust account. Does that make sense for you guys? We only take money out of trust accounts for one of three reasons. You ready? Everybody ready for the three reasons? Number one, the transaction closed. When the transaction's closed, we can release the money from the trust account. So if it's a sales transaction, what kind of money would we have in the trust account probably? Earnest money deposit. We're free to release it once the transaction closes. If it's a lease, what kind of money might we have in the trust account? A security deposit. When would a lease close? When the tenant does what? Moves out. Not in, out. When they move out, we can release the money from the trust account. Whether we release it back to the tenant or release it to the landlord, we're free to release it because the tenant's moved out. So, number one, when the transaction closes. Number two, court order. Court tells us what to do with it. Or number three, what's preferable to a court order? Who does this money belong to? Buyer and the seller. So what would be preferable to have them having to go to court and get a court order? They agree. When the parties agree on how to disperse the funds. If we can get them to agree, do we need to go to court? No. You tell me what you want to do with it. Now, does that mean one party tells you what to do with it? No, it means both. Those are the three reasons you can disperse money from a trust account.
Bless you.
3 years later.
Okay? Examples of money that goes into a trust account. Earnest money deposits, tenant security deposit, rent. If you collect rent of any type, it must go into a trust account. You do not, listen to me now, you might see it on a test. Landlord writes a check for the rent, payable to the a tenant writes a check for the rent. Sorry. The tenant writes a check for the rent, payable to the landlord. You pick up the check and you go deposit in the landlord's bank account. Can you do that?
No.
No. Why? Because rent that you touch goes where? In a trust account. Always. So how's the landlord going to get paid their rent? They're going to get paid from the trust account. And if you're smart in managing your trust account, are you going to pay them the next day? No, you're going to wait for what? You're going to wait for that check to clear. So is there going to be a delay in them getting their money? Uh-huh. Better believe there is. So if you hire you as a property manager, they better know they're not getting that money on the first of the month. Because if you get it on the first of the month, you got to wait 2 weeks for that check to clear. It's going to be the middle of the month before they see a rent check. Okay? You can't. People say to me, well, can I cut it sooner? Sure. What you going to do if that first one bounces, though? That's a problem. We good on that? It's got to be a separate account. You keep the money completely separate from your own money. What do we call it when we have an imbalance in a trust account? Any imbalance in a trust account. Commingling. Too much money in the trust account? Commingling. Too little money in the trust account? Commingling. You don't keep the proper records? Commingling. Anything that's wrong with a trust account is called commingling.
So if you rent out your own house, do you need to put the rent money in a trust account?
What are trust accounts designed for? Whose money? Whose money?
Buyer and seller.
Whose money? Whose money?
For a trust
Whose money?
The trust.
Belonging to someone other than the broker. A trust account is for other people's money. So now ask the question again. No, ask your question.
If you rent your own property,
If you rent whose property?
your own.
Oh, so if it's your own property, who's the rent belong to? Huh?
Sale.
Talk to me. Whose money is it?
Belongs to you.
So do you need to put in a trust account? Ah, I love it when they answer their own question. Does that need to go in a trust account? No, because it's not other people's money.
So it's not considered commingling if you put it in your own checking account?
No, because
How's it commingling?
It's
Whose
your
money
money.
is it?
It is your money, but it's not
Are
your
you-
personal
are-
money.
Why is it not your personal money? You said it's your personal property.
Are you thinking that you're managing the property, or you have a property manager who's managing it?
No, it's your
for you?
own house and you're renting it out.
Okay.
Uh-huh. So explain to me how that would need to go in a trust account. At what point is that somebody else's money?
Guess you're thinking about it.
the deposit.
It's not. It's not somebody else's money. The money that goes into a trust account is somebody else's money. As a matter of fact, it would be commingling for you to put it into the trust account. Because what is the definition of commingling? Mixing your money with other people's money. And if that rent belongs to you, putting it in the trust account is a violation because it's your money.
Does it matter how many owners for the house?
Does not. Because you're one of them. It's your money. Your money doesn't go in a trust account. Now, tenant security deposits. That is not your money. Who does it belong to? Not just the tenant. You and the tenant. But the fact that it belongs to both of you means it goes where? In the trust account.
So you still need a trust.
If you're going to hold it, if you're going to hold what?
Deposit.
A tenant security deposit. Yes, ma'am. You need a trust account. Okay? So, we are allowed to keep up to $100. You need to know that rule. Up to $100 of your own money in the trust account. The reason is for bank fees. If Bank of America charged me a $12 service charge, I need to make sure that money's coming out of my money, not out of my client's money. Does that make sense? Because if I only have my client's money in there and the bank charges a service fee, that money's deducted from their money. And that's not a good thing. Okay? So you're allowed to have up to $100 of your own money in there. It can be interest bearing, but you have to remove the interest monthly. If you have an interest bearing trust account, you have to remove the interest monthly because that money belongs to who? You. So you've got to remove it as soon as it hits the account. You've got to take it out. All 18 cents of it. Write a check to yourself. It's really only worthwhile if you have very large balances in your trust account. So like if you are a huge property manager, let's say you got, let's say you've got $2 million in tenant security deposits sitting in a trust account. Would you want to have that be an interest-bearing trust account? Yes, absolutely. Absolutely. All right? It must be in a bank. You'll see that as a test question. In a bank, doing business in North Carolina, bank. Is a credit union a bank?
No.
No. Is a savings and loan a bank?
No.
No. It must be a bank. There's a difference. The difference is that banks have FDIC insurance. The Federal Deposit Insurance Corporation covers banks, not credit unions. Credit unions have their own type of deposit insurance, but it's not FDIC insurance. FDIC insurance is much better than the credit union insurance. Here's why. Anybody know what FDIC insurance covers? What the amount it covers?
Oh, that's the one with that little black tag that you see when you go in the
Every time you go in the bank, right there on the teller's name tag, it'll have a FDIC logo on there. So the Federal Deposit Insurance Corporation was created after the Great Depression because when banks folded up, they didn't have people's money. So it is designed to protect against a bank that goes bankrupt. You can still get your money out because who's going to fund it? The FDIC. The federal government's going to fund it. Okay? Up to $250,000. Okay? So you are covered if you have deposited in any bank in this country up to $250,000. So if you've got more than $250,000 on an account, what should you do? Take it to a different bank. Because you can have multiple accounts at multiple banks up to $250,000. Here's the reason the North Carolina Real Estate Commission requires you to have it in a bank. If it's clearly labeled trust account, and does it have to be clearly labeled trust account?
Yes.
On where?
Check.
Checks, deposit slips, statements. All have to say trust account. The FDIC will actually protect every individual client within your trust account up to $250,000. So you could theoretically have $10 million on a trust account and it would all be fully insured as long as each individual client didn't represent more than $250,000. Does that make sense for everybody? That's why the Real Estate Commission requires you to use an FDIC insured bank for your trust account. Okay? They do not have to have a physical branch location in North Carolina. They just have to be doing business in North Carolina. Alright? Like as I said, it can be interest bearing. All the checks, deposit slips, and statements must be labeled trust account. Firms do not have to have a trust account. It is not required. Unless they're collecting monies that fall under the definition of trust money. So if a firm's going to hold earnest money deposits, do they need a trust account? Yes. If a firm's going to collect rent, does it need a trust account? If a firm's going to collect tenant security deposits, does it need a trust account? So the answer of do you have a trust account should be dictated by what kind of money do you handle. Because if you handle those monies, you need to have a trust account. And you don't have to have different ones for different lines of business. You could have one trust account and have your rentals and sales and all in the same account. Now, I don't recommend it. I think it gets very confusing. In fact, when I did property management, I always had two separate ones for the property management. I had one for just the tenant security deposits and another one for the rent going in and out every month. But you don't have to do that. You don't have to do it that way. All right? We talked about disbursement. At closing, or when both parties agree, or when you get what? A court order. Those are the three circumstances. At closing, when both parties agree. Here's the thing. You're going to see, let's talk about this for a second. The standard offer to purchase and contract from the North Carolina Association of Realtors. What does it say about the earnest money deposit? Talk to me. Don't leave me hanging. The standard offer to purchase and contract from the North Carolina Association of Realtors. What does it say about the earnest money deposit? If you don't know, you better be putting your notes to go back and look at that standard offer to purchase and contract. If you see questions about it,
It's refundable.
refundable when?
Before the due diligence period.
Before the what?
Due diligence.
The due diligence period ends, right? And what after?
It's not.
Non-refundable after the due diligence period. So, before the due diligence period, the buyer terminates. What happens to the earnest money deposit?
Thank you.
It is what?
Refundable.
Refunded to the buyer. Buyer terminates after the due diligence period. What happens to the earnest money deposit? It is forfeited to the seller as what kind of damages? Liquidated damages. Now, it's great that you know that answer. You're holding an earnest money deposit. Due diligence has come and gone. Buyer terminates. Buyer breaches the contract. They are not going to close. What does the contract say is going to happen to that earnest money deposit? It's going to go to who?
The seller.
To the seller. That's what the contract says. What are you going to do with the earnest money deposit? What do you do? What do we do with it?
You can't release it until they agree.
We hold it. We hold it until what? One of three things.
Agreement.
Closing, which ain't going to happen at this point,
Breach.
or agreement, or
Breach.
court order.
Oh, of course.
You have to be super careful of that on a test. If they're asking you what the contract says happened, you say it gets forfeited to the seller. If they're asking you what you do as the escrow agent, what do? You hold it until they agree or until there's a court order. So what we're saying is when that buyer terminates the contract, what do they also have to do with the earnest money? Forfeit it. They have to release it. They have to say, I'm fine with you giving it to the seller. If they don't say that, what do we do with it? We hold it. Seller gonna be pissed?
Yes.
Absolutely. Don't matter. Do you see what I'm saying there? There's a difference between if they're asking you what the contract says will happen to it and what we actually do. We don't play referee. We don't referee it. If they don't agree, the only referee is down at the Wake County Courthouse. Go talk to them. Otherwise, come talk to me when you agree. Everybody good with that? Okay? That's what we mean when we say we don't disperse unless they've agreed, unless we have a court order. Okay? Tenant security deposits, we don't have to wait for somebody to agree. As a property manager, if we're holding a tenant security deposit, we can disperse those funds as soon as we are closed on the transaction, which is what? The tenant has moved out. We are free to disperse those funds when the tenant's moved out. We're going to talk about for what reasons we can charge the security deposit when we do landlord and tenant. But y'all didn't want to do landlord and tenant. Okay. Aren't you glad you chose real estate commission rules for tonight?
My brain is like mush.
Aren't you glad? I told you it was fun. You need to know the deadline.
This is on the test.
That
Midterm.
was.
Everything is on the test.
I meant midterm.
You need to know how long you have to deposit trust funds. So give me examples of trust funds. Talk to me about what are trust funds. Earnest money, security deposits, what else? The one everybody always forgets. Rent,
Oh, yeah.
earnest, tenant security deposits, rent, right? All trust funds. Don't forget it. You think it might show up on a test? If you consistently forget it, is it something they're going to ask you about? Absolutely. Yes, it is. How long do you have to deposit trust funds? 3 what? 3 banking days from when? From Christmas, from Halloween, from your birthday,
Have to receive.
from the date you receive it. Maybe. What if I don't have a contract yet?
When the contract is formed and you receive the funds, that's when it's 3 banking.
When a contract is formed and I have the money. Both.
The clock starts ticking.
Y'all know what that means?
Yes.
Why'd you tell me a lie? Yeah, you just lied to me. I know, because not a single one of you know what I just said. You say yes because I'm asking a question. Not a single one of you know what that means. So,
You can't have one.
yeah, I'm going to ask you a question.
Okay.
I got an offer today on a listing night. Offer came in with the earnest money deposit check attached to it. With me? Okay? So, I have presented the offer to my seller, and on Wednesday morning, they sign and accept the offer. And we communicate acceptance back to the buyer. What day do I have to deposit that check? What's the latest possible time I can deposit that check?
Monday.
Saturday.
I really didn't hear the question.
I didn't hear the
Got an offer. I got an offer today. I got an offer today on my listing.
Okay.
Earnest money check came attached to it.
Okay. Friday.
Earnest money check was attached to it today when I got it. So the check's in my hand today.
Okay.
On Wednesday morning, my seller signs and accepts that contract, and we communicate acceptance back to the buyer. When do I have to have that check deposited?
Friday. Monday.
By
Cause
Saturday.
that's
The
the
first
Thursday
answer
and
was
then-
right.
Oh, it's
Monday.
Yeah, that's 3
Thursday.
Because it's 3 banking days after we have both things in place. The contract and the money. The clock's not ticking today because I have the money, but I don't have what?
The contract.
The contract. It's not until Wednesday that I have both. So day 1 is going to be Thursday, day 2 is going to be Friday, day 3 is going to be Monday. That check doesn't have to hit my trust account until next Monday.
Well, what if the
Even
bank,
though it came into my possession this Monday, today.
what if the bank is open on Saturday then?
That's what I'm saying.
We don't count
We
banking
don't.
days, Monday
Okay.
through Friday.
Okay,
Monday through
so
Friday.
Monday through Friday.
Because even banks are open on Saturdays, aren't actually depositing on that day. Those
Okay.
deposits don't post until Monday, so.
That explains a lot.
So they're open, but they're not open.
But they're not, got it.
The branch may be open, but it's not a banking day.
Okay, got it.
Banking activity is not taking place till
I have
Monday.
that.
Yeah, yes, yeah.
Yeah, they don't run the batches until Monday. Okay? All right? Is everybody good on that? So, same thing, give you the same kind of question. I'm a property manager. Josh comes and fills out an application on a property today that he wants to lease. Okay? We process his application. We accept him as a tenant. I send him a copy of the lease on Wednesday, and he signs the lease and sends it back to me. On Thursday, he drops off tenant security deposit and first month's rent. When do those checks have to be deposited? Tuesday. Why not Monday? When I told him that he had been accepted and sent him the lease. Because I didn't have the funds. You see, it's got to be both. I have to have the accepted contract and have the money in hand. And then the clock starts to tick. So it doesn't matter if I get the check first or if I get the contract first. The clock starts when I have both. Does that make sense for everybody? So 3 banking days from when I have both in hand. Day one's always the day after. All right. In other words, if I get check and contract today, day one is tomorrow.
Okay.
Everybody good on that?
So is it 3 days when it's also just a rent payment?
Any trust fund.
Okay.
Any trust fund that comes in.
So then it's just the rent, not, you don't need you won't have a contract.
We already have a contract.
Right.
We already have a lease, right?
Okay.
So with rent, it's going to be 3 days from receipt every time because we're already under contract. We wouldn't be taking rent if we weren't already,
Right.
unless when we take rental applications. When we take rental applications, do some property managers collect tenant security deposit and first month's rent along with the application?
Yes, they do.
They do. We don't have a contract yet. Does that make sense for you guys? Because we don't have an accepted lease, so has the 3-day clock started to tick?
No.
It has not. Now, don't confuse the 3-day clock with saying I can't deposit the check. Remember, the Real Estate Commission's rules are all about what? No later than. Can I deposit the check?
Yes.
Yeah, I can deposit any check that's got my firm's name on it and is in my possession. So can I deposit his rent check before I even process his application? Sure I can, if he gives it to me. But that I don't have to deposit it until 3 days after we're under contract and I have the funds. Does that make sense for everybody? Okay. Let me ask you a question here. Suppose Josh does give me his tenant security deposit check. Well, actually, let's just say he gives me an offer to purchase with an earnest money deposit check. Okay? I deposit the check today before I even present the offer to my clients, the seller. Can I do that? I just said, literally just said, if I have a check in my possession, I can deposit it. Literally just said it, right? That's how much you don't listen. You sit there and you nod along, but you gotta pay attention to it, right? Can I deposit the check?
Yes.
Absolutely I can. Now, my client does not accept the offer. What do I do with that earnest money deposit?
You hold it. You give it back immediately.
Give it back immediately. Why? Why does my seller not have to release it?
Because, for one thing, you're within the due diligence period.
Doesn't matter.
Doesn't matter.
There's no due diligence period.
Okay.
They never had any claim to it because they didn't agree to the contract.
Oh,
The
right.
reason I need both parties' permission is because the money belongs to
Both.
both parties.
Right.
But it only belongs to both parties when we actually get an accepted contract. Does that make sense for you? So the same thing with the tenant security deposit. If I take his tenant security deposit when he applies, and then we don't approve him as a tenant, what do I do with the tenant security deposit? I immediately give it back to him. Do I have to wait for the landlord's permission to do that? No, because the landlord has no claim on it because we never had a contract. See the difference there? Yes, ma'am.
Do you run into the possibility of the check not clearing?
Yes,
So do
and
you-
that's gonna be a problem,
Right.
because I might not be able to refund it to him for 14 days, because I might have to wait for it to clear. Is he gonna be mad?
Yes.
Absolutely. So it's probably not a good business practice to deposit that check until we have a contract. I have never in my career deposited checks before we were under contract for that very reason, because I didn't want to be in a position of saying, well, we don't have a contract, and that person demanding their money back, and I said, well, you have to wait 14 days for your check to clear.
Right.
Because what happens if I refund his money and then his check bounces?
You're out of.
I'm out of the money. Exactly. Because I have to fund that shortage in the trust account. Okay? Are we kind of understanding the rules around the trust account now? All right. So 3 banking days after we have money in contract. Of course, provisional brokers turn funds over when? Immediately to your broker in charge. Last slide. And then we'll do a couple more chapters before you go home.
Anything else tonight? I'm good at much right now.
BPOs. BPO stands for Broker Price Opinion. Broker Price Opinion. What does that sound like?
The broker giving advice on what you should list.
The broker giving advice, well, you said on what you should list. I'm going to say that's a CMA. That's a market analysis. A BPO looks an awful lot like a CMA. If I'm giving advice on what I should list a property for, who am I talking to? The seller. And why am I giving them that advice?
Because you're listing their.
Because I'm going to list their house. That's a CMA. So, do the same process, but now I'm not talking to somebody who I'm going to represent. That's a broker price opinion.
You're not talking to anybody, not a seller, not a buyer.
I'm not talking to anybody I'm going to represent. I'm talking to somebody,
Okay.
but not somebody I'm going to represent.
Oh, you're not talking to a client.
Who would ask me what something's worth other than my client?
Bank.
A bank. Especially a bank that's thinking about foreclosing on a property, right?
Bank.
If they've got the note on that property and the person's not making a payment and they're seriously contemplating foreclosure, isn't a big part of that decision going to be what the property is worth?
Yes.
How do they know what it's worth?
Who?
The bank.
Oh,
How's the bank going to know what it's worth?
appraisal or
Well, they could get an appraisal, so why don't they get an appraisal? But, so what if I know? What if they want to know what a property's worth? Who is the ultimate expert on what a property's worth?
an appraiser.
An appraiser. So why don't they go to an appraiser? Why do they come to me?
So they want you to sell
No, I'm not going to sell. I just told you, I'm not going to sell this house. I'm not going to have anything to do with brokering this house. Why do we shop at Walmart rather than Best Buy for a television? Because it's cheaper. Why is the bank coming to a real estate broker for this opinion of value rather than going to an appraiser? Because it's cheaper.
Okay.
A broker price opinion is exactly what the name says. It's an opinion of the pricing or value of the property done by who?
The broker.
A broker. But instead of being done by, we normally, when we give pricing opinions, who are we giving that opinion to?
Our client.
Our client, right? That's part of our job. We give them an opinion of value. But these are people who are not our clients. They don't want to be our client. They're not calling you saying, hey Travis, I want you to list this house. They're calling me saying, Travis, I want to what? I want to know what it's worth. That's it. That's all I want you to do for me. Don't talk to me about how much you charge me to sell it, because you're not going to sell it. I don't want to know. I want to know what it's worth. How much you charge me for that. That is a broker price opinion. And they do it because they can get the same information from us that they can get from an appraiser, except they can get it what?
Cheaper.
Cheaper. It's called a broker price opinion. We can do those if we are non-provisional brokers. Provisional brokers are not allowed. So if you ask a question about BPOs, what do you think it's going to center around?
Provisional or non.
Whether you're non-provisional or provisional, because provisional brokers cannot do them. The other thing you need to recognize as far as broker price opinions is this phrase, probable sales price. Probable sales price or probable leasing price. You have to use that exact terminology.
Okay.
If it's a BPO, the Real Estate Commission says you have to use that terminology. Probable sales price or probable leasing price. And you can't do it until you get rid of what status? Your
Provisional.
provisional status. So you got to finish your You know, post licensing, how many hours of it? 90.
hours, 3 classes.
Y'all think twice next time I give you a choice of what you wanna do?
Yes.
I told you to pick your poison.
This is awful.
I chose it.
Oh.
I got
Chose it.
snake venom now.
That's it,
What?
that's it.
And
So now turn to chapter 11. I'm kidding.
There's some.
Alright, so I will see you all on Thursday night, Wednesday, sorry.